Welcome today, everybody. And so a little bit of background about me. I have been in the role of copyright librarian at the University of Illinois Library for 2 years. Prior to that, I taught at the law school for 10 years. And I kind of had a career change, and I decided, hey, what else can I do with a law degree? And I decided to get my MLIS, but I didn't really want to become a law librarian. And I thought, what else can I do? And copyright librarianship was something that was kind of a new field. And at first I thought, copyright law, that sounds incredibly boring. That is not something that I want to do. And then I realized after taking a class in copyright law at the law school that it's actually a lot of fun. Copyright law is all about art and writing and libraries and preserving our history and just wonderful, fun things. And I realized that it was a great thing to do. So here I am. I hope that after today, you agree with me that copyright law is not scary, but it's empowering. I know a lot of people are a little intimidated about copyright law when they first kind of engage with it because it can be a little bit challenging. But we're going to try to break things down in a way that makes sense. And I am going to keep my eyes on the question box. So I'll try to answer questions as they come, but have no fear, we'll probably have lots of time at the end for additional questions as well. So it is a little awkward when I'm talking at a computer screen, and I know a lot of you are there, so please feel free to post questions as you have them. And like I said, I will try to answer them in due time. So let's move. Let me see if I can move along. All right. So everyone in this online space is a writer, right? I mean, if nothing else, you probably write a grocery list, but some of us, are publishing or we're writing, memos or things like that, emails. We're posting things on Twitter. So I want to do a quick poll just to get the feel of like how everybody views their own authorship. So this will be our first attempt at a poll. If the poll is now open, and the question is, do you own a copyright? It's a simple yes or no. And if you see the poll, go ahead and vote yes or no. And let's see. Where do I see the poll?
You don't see it on your screen? Sometimes
nope.
it shows for our presenters and sometimes it doesn't. So okay, but I'll read it to you.
Sure.
42% said yes and 58% said no.
Well, that's actually pretty good. Pretty good statistics, because usually I get maybe like 1% saying yes and most people saying no. So that shows me a bit about the room. You guys are a little bit savvy about copyright. That's great. Because the answer is, of course, that all of you own a copyright. And probably a bunch. So first, let's say, what is a copyright? So a copyright is a bundle of rights provided to authors with an end date, right? So it stems from the United States Constitution, where it says that we have the right as authors to own our works for a limited period of time. And of course, a lot of this is about economics and kind of trying to get people to create things, right? We create things like J.K. Rowling's Harry Potter because A, we just really love writing, but B, it's a way to make a living, and that's why we do want to give them an exclusive right for at least some period of time, the authors. But at some point it's going to end and go into what we call the public domain so that the rest of society can benefit from it. So what are the requirements to own a copyright? They're pretty simple. You have to create something in writing, music, video. So there's an element of creativity, and the element of creativity is actually pretty low. My daughter's artwork probably satisfies that element. Obviously, the more creative the work, the more it's protected, right? So if I just draw a little a little smiley face, that's not going to be highly protected in copyright because it's really easy for someone else to do it and they recreated it on their own, so they're not actually quote unquote copying mine. But if I draw Picasso, now that is a lot harder to do and that's going to have a higher level of protection. But the bar is really low for what is minimally creative. Obviously, facts are not protected in copyright. So the date of World War II, you can't copyright that. You can't copyright a recipe because it's just a list of facts. So creativity is the first requirement. The second requirement is that you must fix it. What that means in the law is that you have to write it down or record it or type it into your computer. The amount of time for something to legally trigger fixation is actually pretty low. So there have been cases about like how many seconds is something in, your computer file before it gets deleted. It's really, generally speaking, if you wrote it down, if you put it in the computer, if you emailed it, if you recorded it, then that is probably enough for fixation. And what that means also is that it's probably not enough if something's in your brain, right? Like an idea that I haven't written down, that's not protected. But after 1989, that's it. You've got a copyright, and the length is generally the life of the author plus 70 years, which is a very, very long time. So if I die today, everything that I've written will not fall into the public domain until 70 years from now. And that is, like I said, quite lengthy. There are some countries that are even longer. The longest that I know of is Mexico, which is life of the author plus 100 years. But generally, the shortest is usually life of the author plus 50. So there's a range there. What's required under the Berne Convention, which is an international convention that most countries have joined, almost all the countries in the world, is that we have to at least have life of the author plus 50. So that's why most countries are defaulting to that. And this is for author created work. It's a different standard if it's a work made for hire, which is owned by the employer. So that would be a different length of time. All right, so what rights do you have in copyright? You have what we call the bundle of rights. You've probably heard of someone referring to the bundle of rights. They're provided in Section 106 of the Copyright Act, and they include these things. So the right to reproduce your work or make copies, the right to distribute your work or, give it to people or, make copies and sell those copies, the right to create derivative works. One of the best examples that I use of what is a derivative work is fan fiction, right? So if I write another novel and I'm using the ideas of the characters from Harry Potter, but I'm having them do all sorts of different things, technically that work is illegal. I should have asked permission to write that work. Now, a lot of folks then get really queasy because they say, oh no, I do fan fiction all the time, or I read fan fiction. Well, my response to that is, what's the risk of the author suing their fans? Not very high, right? Because they want their fans to write things and read their work, because if you're writing fan fiction, you're probably reading all the work too. And the other thing is usually fan fiction, when it turns problematic is when it starts making a lot of money, right? So you'll see those lawsuits come up, like from Gone with the Wind to The Wind Done Gone. They got sued because they were making a lot of money. In that instance, actually, I believe the author of The Wind Done Gone ended up winning because her work was so different that it was no longer a derivative work. But anyway, regardless, that's my whole spiel about fan fiction and what's a derivative work. So the other rights that you have is the right to perform the work. So if you have, like, let's say a theatrical piece, you have the right to perform that work and to publicly display that work. So you might have the right to show it in an exhibit or museum or something of that sort. So that's what rights the author has to their work. And they have the right to license any of the above to third parties. And you don't have to license them whole cloth. J.K. Rowling has teams of lawyers, I'm sure, who engage in negotiating her contracts, and they're very lengthy and very specific, and I'm sure she's, you know, not necessarily giving every single derivative work to, you know, Harry Potter to like her publisher, for instance. And so you have author's rights, and I do a lot of talking about that for folks. For instance, I publish my work with academic publishers, and until I sign my rights away, I own the work. And so it's really important to me to try to talk to the publisher and to retain as many rights as I can instead of just signing the paper without reading it or thinking about it, because you really do have some rights to negotiation there. Okay, so that's the rights that we have. Basic copyright. What does copyright protect? What doesn't it protect? So copyright protects writing, choreography, music, visual art, film, architectural works. So a lot of stuff. A lot of stuff we deal with in libraries, right? A lot of books, a lot of art and things like that, film, music. We have all of these things in libraries. What it doesn't protect are ideas, as I mentioned earlier, facts, names, titles, slogans, or short phrases, which might be protected in trademark, which is a whole nother set of rules. Data, which with a little asterisk, because if it's arranged and composed in a very specific way, there might be a thin layer of copyright over the data, but generally data is a compilation of facts. So therefore it's not protected. And then useful articles, because that's a patent protection. A useful article is something like a chair, right? Or like a computer method or process or program. Software itself can be copyrighted, but the like method of operation is generally a patent. So those are the things that it doesn't protect. So we're talking about everything on the left today. We're not talking about trademark. We're not talking about patent. I know enough about trademark to be dangerous. I know so little about patent that I would be really dangerous because I would tell you things that are just wrong. So, you know, if you ask me questions about those things, I'll probably just say, hey, that's a trademark question, or hey, that's a patent question, and kind of move on. So just want to let you know that that's not my area. I try to stick to what I know, so I'm not giving out false information. All right, so who owns the copyright? The author, of course, owns the copyright, but who is the author, right? The author is the person or people who created the work, except for work made for hire, which is when the employer would own the work, right? So if I am employed by a school district and as part of my contract, I'm supposed to be creating lesson plans and I do them in the course of my 9-to-5 work and they take out benefits from me and all this stuff and they can direct my work, then that work would actually be owned by the employer and not the employee. Now, if there are joint authors, this is an interesting default rule that a lot of people are not aware of. The Copyright Act says that each owner has an equal, undivided interest in the copyright, which is just an interesting thing because a lot of times I see articles that are published by like 10 people and the 10th author did very little on the work, right? They're usually put in order of how much work they did, the first author being the most important. But if I call up the 10th author and I say, hey, can I put this work on my webpage? If that author hasn't published the work with anyone and hasn't, you know, gotten into an actual written authorship agreement with the other authors, then technically they can say, sure, put it up because they have an equal undivided interest in the whole work. So it's sometimes important to have an author's agreement if you don't want the default to prevail. The default there would also be that each author, if money was made, would have to split it equally, which really wouldn't be fair if you're the 10th author and did very little work. So, you know, in a lot of businesses, author agreements are a big deal. Just something to be aware of. Okay, let's move on to the public domain. All right, so this term is thrown around a lot, and I find when I ask people what does it mean, they don't really know. So I want to define it first. So public domain means work that has that copyright, where the copyright for that work has expired. All right, so it's in the public domain because there's no copyright anymore over the work. Why? Because it's so old. For instance, my work, like I said, today, if I create something today, will enter the public domain if I died today, 70 years from today, right? And then everything that I did would fall into the public domain. Even if I transferred it, let's say I published stuff with a publisher. I'm actually working on a book with ACRL. Let's say I published that. The publisher can only own the rights that I had, right? So they can't own the copyright any longer than I myself would have owned it. So if I die today, again, they would have it for 70 years, and that would be the end of the copyright. It would end up in the public domain. The rule of thumb right now is that work published in the United States before 1923 is in the public domain. It's a really nice rule of thumb. It's really easy to remember. And so if you hear people talking about, oh, before 1923, that's what they're talking about. I didn't include international works there because it really, there's kind of some disagreement among the courts about whether international works fall under that or not, and it depends kind of where you are. But, you know, some people also include international works there. The other thing I would point out here, and this is a really important thing to note, is that United States copyright law is not retroactive. What I mean by that is that the law that applies today, like I said, the current copyright term is life of the author plus 70 years, is not the same as the law that applied in 1922, for instance. And US copyright law has been amended over time. And this is why I think, I mean, I could be wrong, but I think this is one of the reasons why people get so confused about US copyright law, because it has changed over time so many times. All right, so one of the things people get confused about with US copyright law is that they think, oh, I don't have a copyright because I didn't register my copyright officially with the United States Copyright Office. And as you know from earlier, did I say that that was a requirement to have a copyright today? I didn't, because it isn't. And again, this has to do with the United States joining the Berne Convention, and one of the requirements of Berne, which is like an international kind of treaty agreement on copyright, is that you're not allowed to have what's called formalities in order to require copyright. So you're not allowed to require people to put, for instance, a copyright symbol on their work. You're not allowed to require people to register the work to make it an official copyright. So today, whether I put a copyright notice on my work or not, even if I put my work on the internet and widely distribute it, it still is copyright protected and the author owns it. Now, there are reasons that people put copyright notices on their work today. One of them is to provide notice to people, right? A lot of people don't understand US copyright law. They don't know that everything on the internet isn't free to use. And so putting that copyright notice on there is a good idea. It also prevents the innocent infringer defense in the court of law. It creates a presumption that the person knew that it was copyright protected. So it helps with the burden of proof. And the other thing is, if you register your copyright, you cannot sue until you do so. So I cannot sue anybody in a court of law until I have registered a copyright with the Copyright Office. And also I can't get the higher damages that I want, the statutory damages that a lot of people think are ridiculous. I kind of think they are too, but the statutory damages are really high and you can't get those unless you have registered your work. So those are a few things about things that have changed over time. So work published before 1923, talking about the retroactivity, the law used to be that it was a set 95 years after date of publication for how long the copyright lasted. There was no life of the author and all this stuff. This was before we joined the Berne Convention. And so if you do math, I'm really bad at math, but if you do math and you add, 1923 plus 95, you should end up with 2018. So at the end of 2018, in other words, January 1st, 2019, we're going to get everything from 1923 falling into the public domain. So this whole pre-1923 is going to become pre-1924. So a lot of copyright folks, including myself, are super excited because a lot of things are going to enter the public domain on January 1st of 2019. And we're going to get a lot more stuff we can do things with, right? When things are in the public domain, you can sell them, you can, digitize them, you can put them on a web blog, you can, make copies and hand them out. You can do whatever you want because it's not owned by anybody. Okay. One other thing I would point out is some of the work published between 1923 and I think 1968 may be in the public domain for failure to comply with copyright formalities. One of the big formalities was that you had to put a copyright symbol on the work in order to get protection. And so if something was published, this is only for published works, not unpublished works, but if something was published and it didn't have a copyright symbol in that era, then it fell into the public domain. And some of you may have heard of the HathiTrust Digital Library copyright review procedures, where they are having librarians go through these works from this era and try to see if they failed the copyright formalities, right? So if they did, then they're able to put them in the HathiTrust Digital Library and put the whole work there. So there are some interesting parts to the public domain. The thing that I would say also to do if you are really interested in different eras in time, or you have older works and you're just like, I don't remember if it's public domain or not, Peter Hurdle from Harvard has a really handy chart. If you just Google Peter Hurdle's copyright chart, it's really awesome, and it goes through all the different eras in the US, and he updates it every single year. So it's a very handy cheat sheet. A couple other tools that I like, one of them is called the Digital Slider. It's really nice too because you just put in, what year the work was published, and it will tell you what the formalities were, or if there are any formalities, or if it's in the public domain. So there are some really nice cheat sheet type tools out there if you're trying to determine if something's in the public domain. Okay. Here's a good question. Why can libraries loan books at all? And I would love to show you this, but it's not going to work. So I'm going to send you the link that you can watch later. It's really funny. But Stephen Colbert did a whole show about, the Kirtsaeng case, and I'm going to summarize it here in a second here. Let's see. The Kirtsaeng case was a case that went up to the United States Supreme Court. And in that case, a student from Thailand bought textbooks that were US produced, but he bought them in Thailand. They were sold there. And then he sold them in the US for a profit because in Thailand, they were sold really cheap, right? Because the market is cheaper there. People can't afford US textbooks. They sold them cheaper. They were in English. He made millions of dollars. His family was just shipping him all these books from Thailand to the US. And the publisher sued and said, hey, that profit belongs to us. Those are our books. And the Supreme Court said, nope. He gets to keep all those profits because of the right of first sale under the Copyright Act, Section 109. And the right of first sale says, you sold it once, and that's what you get, publisher, right? If someone bought the book legally, they're allowed to sell it, right? So that's why we have used book sales. That's why we have those little mini libraries in people's front yards. And that's why we have libraries, right? They buy the books and then they can lend the books, right? So that's why we're able to do that, is the right of first sale. So that's something anybody can do, right? If you buy the book, you're allowed to then, lend it. What you're not allowed to do is make copies of it, right? The library can't buy one book of Harry Potter and then wholesale copy it 10 times and then lend those. You have to one-to-one lend what you bought. Does that make sense? Okay. But anybody can do that. I can have a little mini library in my front yard. I can have, used book sale in my garage, those kinds of things. All right. The other thing I want to point out also is the slavish copy idea. So some people think there's a public domain work and I've made a copy of it on the copy machine and put it online, so now I have a copyright in that copy. That is not true. So the courts have said if you make a slavish copy of a public domain work, you are not creating a copyright in that copy, right? It's already a public domain work. Why not? Well, if you think about the requirements for a copyright, you have originality and fixation. Which one is missing here? What do you think? We have fixation, don't we? Because you're fixing it in a copy. What we don't have is any amount of originality. There's no new creation that you're adding to this work by making this scanned copy, right? And in the US, we do not value quote unquote sweat of the brow. Like, oh, but it took me 10 hours to copy this book. The courts don't care. The courts do not care when they're looking at originality. They're not looking at how much time it took you to make the work. They're looking at how much creativity was in the work. So I do want you to note that if you're taking public domain works and you're making copies of them and putting them online, your library does not own that public domain work. You can't put a copyright, you shouldn't put a copyright symbol on it. It's just what's called copy fraud. Professor Mazzone at the law school here coined that term. He has a whole book called Copy Fraud, when libraries go around saying, well, we own this, you know, and they just don't because it's public domain. So let's not commit copy fraud. Let's, you know, label things appropriately. And I believe Hannah Stitzline talked about the DPLA standards and how to appropriately label things in rights statements. But labeling a work a public domain work, if it is such, is really helpful to the public. Okay, so now we're getting into some of our librarian superpowers. Why did I term this talk Librarian Superpowers? Because, you know, there are certain things that we as librarians can do that everybody can do. So, like I said, Section 109, not super exciting. Right of first sale, anybody can do that. Anybody can have a mini free library in their front yard. Anybody can sell used copies of books in their garage. Lending books that the library purchases, not super exciting. But Section 108 of the Copyright Act is super exciting because it gives librarians powers over in copyright works that not everybody has. So these are superpowers that librarians have, in terms of copyright at least, that other people don't have. So Section 108A is the introductory section, and it basically tells us who can qualify for these protections, for these superpowers. So it says, it is not an infringement of copyright for a library or archives or any of its employees acting within the scope of their employment to reproduce no more than one copy of a work if, et cetera, et cetera. Now, so it's saying Section 108 is for libraries, it's for archives, and it's for any employees of the library or archives. Note what is missing there. It does not say museums. And quite often, I think of a museum as an archive, right? It's like a type of special collection. And most museums do use Section 108, but it's not included. So that's one of the things that was I think a mistake in Section 108 that they've been kind of trying to fix over time, but hasn't been fixed. Plus, there's no real definition of what a library is or what an archive is. I mean, I think we know what it is, having worked in libraries, but interestingly, there's no definition here. All right, and it says we can do this. We can make no more than one copy of work if the reproduction or distribution is made without any purpose of direct or indirect commercial advantage. So we can't be doing it for a profit. That's important. That's why this is for libraries and archives that are not operating for a commercial advantage. And there are more requirements, so I took them out because I thought they were pretty obvious. You know, another requirement is that you have to put a copyright notice on the work. But generally speaking, Section 108A is for libraries and archives when they're working for no purpose of commercial advantage. Okay, so that's the general requirement for Section 108 to even apply. If you're not a library, you're not an archive, or you're working for commercial advantage, then it doesn't apply to you. Okay, so this is why we have this superpower. So let's look at what superpowers do we have. So Section 108B tells us that we can make up to 3 copies of an unpublished work solely for purposes of preservation or for deposit in another library or archives that is open to the public or available to people doing specialized research if, and then it has a bunch of requirements. Okay, now first of all, this is basically the best friend of an archivist or preservation specialist. So you're allowed to make up to 3 copies of an unpublished work because that may be the only work in existence, right? If it's unpublished, it means there are very limited quantities. So we want to be able to make these backup copies for preservation or to put in another library. Let's say they had a copy and they lost it, right? You're allowed to make that copy if you currently have it in your collection and any copy reproduced in digital format is not distributed outside the premises of the library or archive. So we're not allowed to put it on the general World Wide Web, okay? If we want people to be able to see it on a computer screen, for instance, they're supposed to come in maybe to the library, but this really depends on what your definition is of premises of the library. Now, here's a funny thing about Section 108, and kind of a good thing and kind of a bad thing. So usually as lawyers, we understand the law by reading a bunch of cases, right? We say, oh, I don't really understand what premises of the library means. What have courts said about it? You know, maybe there was a court case where someone was like logging in through Shibboleth, for instance. Is that the premises or not the premises? Like I can access my library's materials all the way from Poland when I'm at a conference. Is that in the premises, so to speak, or not? The good thing about Section 108 for librarians is that libraries haven't been sued under this provision. That's great. That means that we've been doing our work of preservation and digitization and we're not getting sued. The bad news is that it's not well defined and we don't have any way to define it. So it just depends on kind of who you are and how you interpret things. I know people who interpret premises of the library, they say, well, you know, this was written in 1976 and you know what they meant back then. They meant like the physical building. If you want to see a digital copy, you're going to have to come into the actual archive. Then there are other people who are really more forward thinking and saying, hey, you know, libraries have changed a lot over time and law should change with it. And we understand premises to mean anywhere you can log into the library. And so if you have a password to log in, then it's okay to be, you know, there. We're not talking like the open web, we're talking like a password or something. So again, that really depends on your interpretation of the law, but it is easy, relatively easy, to make up to 3 copies of an unpublished work, you see, for preservation. There's no other real requirement except that you have it in your collection, okay? Because we want to preserve those things. So it boils down to a fairly broad right to make reproductions of unpublished work for preservation, but the digital copy cannot be sent, for instance, via email or put on the general web. Individuals wishing to view the digital copy must come to the physical location of the library, or if you view your location of the library premises to be digital, they should have like that password, okay? Let's look at Section 108C. Now this is talking about published work. 108B was talking about unpublished work. So for published work, we can make up to 3 copies still of a published work, but it has to be, see, there's more restrictions here. Duplicated solely for the purpose of replacement of a copy that is damaged, deteriorating, lost or stolen, or if the existing format in which the work is stored has become obsolete. Aha, so this is where, yes, we have some superpowers, but they're limited, right? Because if it's published, we're going to assume we could maybe buy a different copy, right? We lost a copy of Harry Potter. Well, instead of just going and getting a copy from another library and copying the whole thing, we should probably purchase another copy. So here's what it says. So first of all, it has to be for purpose of replacement of a copy that's damaged, deteriorating, lost, or stolen, or if the existing format in which the work is stored has become obsolete. And we have to determine after a reasonable effort that an unused replacement cannot be obtained at a fair price. Notice that it says an unused replacement. We're not talking about a used replacement. So we're not talking about the secondary marketplace. We don't have to go and look for resale. We have to find an unused, a brand new copy at a reasonable price. And if it's not a reasonable price, then we can say, hey, we're just going to copy this from someone else or somewhere else, right? Another library, for instance. And same thing, any copy that is reproduced in digital format cannot be made available to the public outside the premises of the library. So we have that premises of the library problem again. What does that mean? Okay. So then that probably leads you to question, what does an obsolete format mean, right? Because as we saw before, it said, or if the existing format in which the work is stored has become obsolete. What does that mean? Well, Congress gave us a little bit of a heads up there, and they said, a format shall be considered obsolete if the machine or device necessary to render perceptible a work stored in that format is no longer manufactured or is no longer reasonably available in the commercial marketplace. Okay, so I love how legalese this is, right? A machine or device necessary to render perceptible work. That is crazy talk, right? Why couldn't they just use plain English? But this is how lawyers talk, sadly. And it makes sense, right? So it's obsolete if you cannot actually like view the thing because you can't get the device necessary to look at it or listen to it. It's no longer manufactured or no longer reasonably available in the commercial marketplace. Now, it doesn't say anything about the secondary market here, and I think that you could say that you have to look at the secondary market, say for like VHS recorders and things like that. But let's look at some questions about this. So I've got some polls here because I want to see what you guys think. Are the following technologies obsolete pursuant to 108C? So in other words, can we make copies of these certain things to preserve them because they are obsolete without, purchasing, a new one or something like that? So the first one is VHS tapes. We should have a poll pulled up here.
Yep, the poll is launching now. I'm going to close it.
Okay.
And show the results. In case you can't see it, 38% said yes and 62% said no.
Yeah, I agree with that. I agree with that outcome. I think that you guys are right, the ones that said no. The reason is I do know that they're no longer manufacturing VHS recorders, players, right? They're no longer being manufactured, but you can buy them online. You can get used ones, you can buy them online. Now, I have heard people argue, my library would not buy used technology. We just would not do that, right? Because that's actually bad practice and it could be broken or whatever. So you may have an argument there. Okay, so none of these things are really set in stone. Again, we don't have any case law, but most people think VHS tapes are, they're not necessarily obsolete because you could reasonably purchase at least used player. And again, there's an argument there that used players are no good, but okay, let's see. What do you guys think about floppy disks? Are floppy disks for computers, are those obsolete?
The poll is launched. I'll give people a few seconds to answer. All right. So 86% said yes and 14% said no.
Yeah, I agree with you guys on this one too. I have heard from our tech guys that it's actually really not that hard to get some newer technology that reads floppy disks, but my response to that is, okay, we're not manufacturing, those old Apple computers, those huge honking computers with the floppy disk things, and it's not like those are in the marketplace anymore, really. So I think those are the ones, but yeah, you can go ahead and you can probably you can consider that technology obsolete. If you have something on there, you can make a copy of it for preservation, right? That's what we're talking about. Up to 3 copies for preservation. Okay. Undeveloped photograph film. What do we think about that?
I just launched that poll. Give people a few seconds to respond. All right. And the results are 11% said yes and 89% said no.
Yeah, I agree with you guys there too, because you know what? They still, I think drugstores still take photograph film and will develop it. So I think we still have that technology going on, and just say, oh, can't do it anymore. Okay, what about microfiche? I have a feeling you guys know the answer to this one, but it was a surprise to me when I first learned it.
All right, poll is launched. I'll give a couple more seconds. All right. So the results of microfiche reels, 16% said yes and 84% said no.
Yeah, see, I originally thought microfiche, I was like, microfiche, that's like ridiculous. They're not manufacturing that stuff anymore. Oh, I was put in my place by an archival person who said, hey, that's the gold standard of like protecting archival work. And yes, they're manufacturing that stuff. I mean, it's expensive, but it always was like, you know, so unfortunately microfiche, you can't just say, oh, it's, you know, obsolete. We're gonna, so this is a pretty high standard for the obsolete stuff. What about records for record players?
Right. I just launched the poll. Yeah. Give folks a few seconds. All right. Closing it out. We had 4% said yes and 96% said no.
Yeah, I kind of gave you a hint there because I was like, thanks, millennials. They're making it super cool to play records. So now there's more and more record players being sold. So they've kind of like brought it back from the dead. So we can't really argue it's obsolete because it's really easy to get a record player. Yeah, so I agree with you guys. Floppy disks are probably obsolete. If you have some in your libraries, like you can start thinking about 108C and is it obsolete? And do we need to, in order to preserve it, make copies of the things that are on it? But you know, VHS tapes, more debatable, and then the rest of it probably can't make that argument. All right, very good. I think I'm right there with you.
Sarah, just real quick, there was a question. You made a comment about the machines for the floppies, but what about the software programs? Does that come into play?
Oh gosh, that's a really good question. So the software program is also copyrighted itself, and I don't know.
What if the software is obsolete? I mean, I think that's the question, not about copying the software, but actually like
if the software is obsolete.
Yeah.
Well, I mean, I think that would be a similar argument that, you know, I cannot render this thing perceptible because the software is obsolete, so I need to transfer it to a new format, make a copy so that I can do that. So I would make the similar argument that, you know, using that definition, I'm going to go back a few slides here, hang on. So they say it's obsolete if the machine or device necessary to render perceptible work stored in that format is no longer manufactured. Now, that's kind of a weird way to look at software, because software isn't quote unquote manufactured, but if that's like an old software and there's nothing that is like it and there's no other way to get the thing off of the disk or whatever it is, I think you could make that argument. But a lot of times there are kind of new softwares. Again, I'm not really a techie person, but I think a lot of times software is like updated or there's a way to hack into it some way. So I think you could try to make that argument. This is really talking about it does say the format, if it's stored in a format that doesn't work, right, that you just cannot otherwise get it, you're going to lose the work. That's what it's about. So, you know, I think, you know, if you can make that argument, then maybe if you feel comfortable with it, that's where you go. I mean, a lot of times people are making these decisions And we don't, like I said, we don't have a lot of guidance, so we're just trying to make a good faith decision. And I would say the risk is relatively low if what you're going to do is make a preservation copy and you're literally keeping it like in a back file or what have you. Now, if you're putting it on the general web, you're not allowed to do that because of this, you know, requirement that it can't be outside the premises of the library, and you're actually like opening yourself up then to risk. So you could do a risk assessment there and say, oh, well, if we're keeping this, you know, in a dark archive, I think it's probably okay. All right.
Thanks.
So we're moving on to interlibrary loan, section 108D. This is a real boon to libraries, right? What we're able to do is we're able to give in copyright works copies. We can give copies of in copyright works to other libraries. It's great. It's a wonderful superpower that we have that I think a lot of people don't realize it is a superpower, but it is. It's not like my little library that I have in my front yard can make copies of things and send them to the library across the street, right? I mean, these are things that we can do in these nonprofit institutions that other folks just cannot do. So it says the rights of reproduction and distribution apply to a copy made from the collection of a library archives where the user makes his or her request, or from that of another library archives. So you have a user making a request or a library archive making a request of no more than one article or other contribution to a copyrighted collection or periodical issue, or to a copy or phonorecord of a small part of any other copyrighted work. So we're talking about, you know, one journal article out of a big journal, or, you know, a chapter out of a book or something like that. They can make that copy if the copy becomes the property of the user and the library archives has had no notice that the copy would be used for any purpose other than private study, scholarship, or research. So I've had people come to me and say, I want this copy because I'm making a movie and I'm going to commercialize it. Well, I can't give it to you now, right? You need to check the box that says it's for private study, scholarship, or research. That's one of the requirements. And we have to display prominently at the place where orders are accepted and include on our order form a warning of copyright. So we have to remind people like, hey, this work is copyrighted. We have superpowers and we can give it to you, but only for like these purposes, right? You can't just go and take this and put it on your personal blog and just copy the whole thing, right? And put the PDF on the web or something like that. So they have to be reminded of their obligations. So note that only a small portion of a book can be copied there. This should be for private study, scholarship, or research use, not commercial use. The request should come through a user or another library archives. The copies for users, there is an exclusion. It cannot be made from musical works, pictorial, graphic, or sculptural works, or motion pictures or other AV works, right? So we don't interlibrary loan copies of movies and things like that because it's actually excluded from the ILL provisions. And this applies to both published and unpublished works. So you can ILL unpublished works too. All right, what if you want to ILL an entire work? Well, this is a lot harder to do. The rights of reproduction and distribution apply to the entire work or a substantial part of it made from the collection of a library archives if the user makes his or her request from that, if the user makes a request or it comes from another library archives. And then here's the big thing. If the library archives has first determined on the basis of a reasonable investigation that a copy or phonorecord of the copyrighted work cannot be obtained at a fair price. So you can't just ILL a whole book that the other library could buy or the user could buy, right? And we're talking about a copy of a book. Now we can send an entire book, right? Like kind of like ship a book ILL. That's not making a copy. That's our right of first sale, right? We're lending the book. That's fine. Anybody can do that. I can lend my book in my front yard to the library across the yard because I own that book. I purchased it. It's the right of first sale. I can give it to them. Great. What I can't do is make a copy of the whole book. You guys see the distinction there? Now here you can if we've determined first that we can't obtain the work at a fair price. So for instance, let's say the work is like just no longer, it's still in copyright, but no one's manufacturing it anymore. It's just out of print. And I couldn't even pay for it because no one's making it, right? That's the type of work we're talking about here. And then the other requirements are that again, they have to be using it for private study, scholarship, or research, not for commercial purposes. And we have to display prominently, again, the warning of copyright at the place on our order form and on our where our orders are accepted, and when we actually send the work, we have to put that copyright warning on there. Oh, how do I display? I got a question here. It says, I work in a special library and get ILO requests directly via email. How do I display a copyright warning? So if you get them directly via email, if you have a web page where it says where to email, it can say, like, please be aware that things may be you know, copyright protected. You also, when you actually send the ILL work, you put the copyright notice on the top of it. I'm sure you probably already do that, but that's the same notice you could put on your web page if that's where people are emailing you. I'm hoping that helps a little bit. I get it that you're just getting email requests, but you should have maybe on your web page where you're telling people where they can email. That's where I would put it so that people just know. And it would be helpful if you had an actual form that they fill out, because then they could check the box that says, like, it's for private study, scholarship, or research, and you're kind of that, and you could also put the copyright warning there too. So you could have them fill out a form and then email you that form. That would be even better. And a lot of libraries have those forms. I think the University of Illinois Library has an ILL form or a digital request form on our webpage, and you could copy it. We don't care. Go for it. All right. So the entire work may only be provided if, after reasonable investigation, it appears that a copy of the work cannot be obtained at a fair price. And there's a lot of discussion about what's a reasonable investigation. Again, we don't really know, right? Like Congress hasn't told us, the courts haven't told us. It's just like, use your best judgment. And notice that it doesn't say an unused copy of the work. It just says a copy of the work. So I do think this includes the secondary market. So if you're looking like Abe's books and you can get the book for like $2, you probably should do that instead of making the copy of the book, right? For somebody, tell them, like, go and buy it at Abe's books for $2 or whatever. So yeah, you got to do that first. You got to make sure you can't just, the user can't just buy it, or the library can't just buy it. Again, this is different than sending them the book, like lending them the book. This is for both published and unpublished works, and it doesn't apply to musical works, pictorial, graphic, or sculptural works, or motion pictures and audiovisual works. Interestingly, there is an exception for news, audiovisual news, and that's because the Vanderbilt News Library, they got sued, and they told their congressperson. That person got very upset, and they added an exception because, do you know what they do every day? They record the news off of TV and they index it. They have someone there watching the news all the time and indexing what the news was about that day. It's so cool. I've been there. It's really neat. They have a lot of legal questions because they have clips of the news that are copyright protected, and they're sending them to people, and it's really interesting. But anyway, it's really an interesting exception. So sometimes these exceptions happen when someone gets sued and then they raise it with their congressperson, and the congressperson says, oh no, we can't have that. We need to have the news indexed. Because guess what? Fox, which I really don't love Fox, but CNN, all those other places, some of them are not indexing their news. They're not even keeping old news. To them, it's like yesterday's news is worth nothing. But to historians, it's worth a lot, right? And we want to know our history in the news. And so that was one of the reasons that Congress said, oh, we're going to make this exception. And yes, it's copyright protected. We're going to let them make these copies for preservation. Okay, and lend them and all that. All right. Just an interesting aside. Okay, so some review. In section 108, there were some questions relating to the following. This was when I did this presentation for my library. They said, what does it mean to make a digital copy, and does photocopying count? So under the Copyright Act, a single photocopy is considered analog. All right, so digital would, remember when it said digital copies can only be displayed on the premises of the library, they're talking about a scan to a PDF or sending it via email or putting it on the web. That's a digital copy. They're not talking about a single photocopy. Okay. What does physical premises mean in Section 108? We talked about this too. This is part of the problem with the analog-digital divide. And today we think of the library as an entire system you can log into off-site. At the time of the enactment of Section 108, it was a physical building. And we don't have a solution to this. The U.S. Copyright Office has been studying Section 108 for years, and nothing has happened. No reform has happened. They've come up with a discussion document, which is 100 pages long. You can certainly read it. You can get it off of the U.S. Copyright Office page. And if you're really interested in Section 108, you can read and read and read. But nothing has changed. So we all recognize that Section 108 is a little outdated. However, the problem with letting Congress get their hands on it again is that they could ruin it too, right? I don't particularly want Congress to try to amend Section 108, even though I think museums are a no-brainer. They should be added. And I don't like this whole 3 copies, because we're clearly making more than 3 copies of things when we're putting them in deep archives and we're making copies on, computers and all sorts of things they didn't have in 1976. However, Congress is very good at messing up the law and making it very bad. And in particular, if they're not library friendly and they're more corporate focused, it's not necessarily going to end up well for us. Also, libraries are not being sued for Section 108. This is a good thing. This means that we're exercising our good judgment and people are leaving us alone. And I'd like it to stay that way personally. Other people have threatened, ooh, Section 108, a big lawsuit is just around the corner. We'll see. I think we've been doing things we're supposed to be doing for a long time, and publishers have left us alone. All right, so I have a hypothetical, and we can do a poll if we got some time. If we can open up a poll, can the library make a digital copy of a published, still in copyright, article about the demotion of Pluto as a planet from its collections for a user for the purposes of private study, scholarship, or research?
The poll is open now.
Okay. Can they make a digital copy, like an ILL copy? Someone says, "Hey, I want this copy." Can they do it?
All right. Results are in. 82% say yes, and 18% say no.
Yeah. So yeah, the answer is yes. Of course, we ILL stuff to people all the time, right? How many of you guys send things via email to people with a attached file? Yeah, we do that all the time. Great. But can the library put the digital copy on the web page? The answer to that is no, unless maybe if you argue that it is, for you've got some other reason that it's, within the preservation policies, and that it is not available like widely, right? That it's only available with password, et cetera, et cetera. But usually the answer is going to be no to that. So there are a lot of things we can do for an individual patron. We're not really just allowed to put things on the internet. Okay, another example. The library wishes to make a copy of an unpublished archival document as it is the only one the library has. Can it? Can it make a copy of that?
Okay, that poll is open. Give everyone a few seconds. And 95% said yes, and 5% said no.
Yeah, so this one is meant to be a pretty easy question, because remember, with unpublished documents, we are allowed to make a copy, whether it's deteriorating or anything like that, right? Those kinds of requirements are for published things. If it's unpublished, we're going to assume we can do stuff, right? Because it may be the only copy there is. So yeah, we can make up to 3 copies. Now the question is, what can the library do with that copy? Can the library let people view it in the library? So if you come into the archives, can you look at it?
Okay, that poll's open. Giving people just 2 more seconds. All right. 94% said yes, and 6% said no.
Yeah, so you are definitely allowed to let people look at it. I mean, a lot of times they want to see the original, but like if that original is lost, the whole reason we have the preservation copy is to have a copy, right? So of course they can look at it. Okay, what about, can people make a photocopy of it? You come into the archive and you want to make a copy. Can you do that?
All right, that poll is open. I'm going to give like 3 more seconds. All right, closing it out. 63% said yes, and 37% said no.
Well, yeah, I mean, they can make a photocopy of it. Of course, you know, they're bound by the copyright rules and they can't just do whatever they want with it. But if they're using it for research and for study, yeah, of course they can make a copy of it. That's the whole reason they came into the archive in the first place, right? If I live in Kansas and I come to the University of Illinois archive because I'm doing specific research and I'm going to go back and write my book in Kansas, I might want to have some of that stuff to reference with me, and that's okay. Can the folks in the archive scan it and make it available on the library website?
Okay, that poll is open. I'm going to give them just a couple more seconds. All right, I'm closing it out. That one, 11% said yes, and 89% said no.
Yeah, so this one is one of those, like, it depends, right? Is it available on the website with like no password protection whatsoever? I would say probably not, because remember there's that, you're only allowed to show it, the copy within, the digital copy within the quote unquote premises of the library. But then if you want to argue, hey, people are going to have to log in to see it, and it's only like within a collection, like through a password, then you could argue that it's still the premises of the library. So it kind of depends then at what your comfort level is with that term premises of the library. I would say, you know, that's a dean level decision. I would pass that one up the chain and say, you know, what do you think, Dean? And kind of move on with that decision there, or the head of the archives. Okay, so
Sarah,
I hope that,
Sarah,
yes.
okay, sorry to interrupt. It looks like our polls have gotten hung up. I'm going to switch presenter controls back to me real quick.
Sure.
And then send them back to you. And then here we go, sending them back to you. So you may have to accept again and then choose your PowerPoint. Sorry about that. Okay, I see your screen again.
Okay, perfect.
Got it.
All right, so I want you to remember that Section 108D and Section 108E, interlibrary loan, do not mention the digital physical premises issue. So there's no like weird, you know, yeah, you can do it. That's why interlibrary loan, we do send things over email all the time, because that's not where they mention it. They mention it when we're talking about making preservation copies. And I also want you to remember that you always have fair use. So some people think that Section 108, which is a clear exception, I mean, clear, I guess clear after we've had this whole discussion is like laughable, right? It's like, I mean, but it is an actual exception. It's saying you do these things, library, and you're allowed to do them, okay? Fair use is one of those things that's flexible. And some people think, well, if you have an actual exception, then you're not supposed to rely on fair use. And I'm going to tell you that that's bonkers. And court cases have said that that's bonkers. And even the law in Section 108 says that that's bonkers. So even where you're pushing the boundaries of Section 108 and you're relying on fair use, that may be an okay thing. All right, so that's why, you know, some people press that premises issue and they say, okay, but also I'm going to rely on fair use, right? So that may be an okay thing to do. So in Section 108F, it says nothing in this section in any way affects the rights of fair use as provided by Section 107. So in other words, fair use can operate in conjunction with Section 108 rights. If you feel like, hey, I'm pushing the boundaries of 108 a little bit here, but I feel like it's still fair use, so I'm going to go ahead. That's an okay thing to do, and I want you to be clear about that. One other thing that's in Section 108 that I don't think is covered here, because I'm pretty sure oh, yeah, hang on. So, yeah, one more thing that I wanted to tell you about is Section 108 has a provision that talks about patrons using photocopy machines, as long as they're unsupervised and have a copyright notice, the library is not liable for that. So that's a really, really great thing to keep in mind, and to make sure all of your copy machines, and I apply it to 3D printers too, and scanners, book scanners, and all of that. Go around your library and make sure that you have copyright warnings and notices on those machines, because that is one of those ways that you are falling in an exception and limiting liability for the library. So if somebody's making entire copies of entire Harry Potter or whatever and putting it on their website, which we all know is wrong, as long as you're not supervising them, you're not just watching them and being like, this is cool, you know, as long as they're unsupervised copy machines and you have a copyright notice there, then the library is not liable for that. And the other thing I would urge you to do is there are some really cool copyright notice documents at the University of Michigan, and they are licensed on Creative Commons, so they're available for use. And I use them, and I just cite it as a CC BY document. And it says, you know, here's what we have to tell you. We have to tell you that, you know, you're bound by law with copyright stuff, and you can't, you know, violate copyright law. And then they say, here's what we don't have to tell you. You also have the right to fair use. And you know, you might think through that right a little bit. And I love that balance, because even though we have to warn them about, you know, the big bad copyright, we also can like empower them that like some of the things they're doing are fair use, and they can go ahead and do it. And with my particular guide, I link to, you know, a library guide all explaining fair use, so that folks can then kind of educate themselves a little more. All right, section 108H, this is a kind of fun section. If a published work is in the last 20 years of its copyright term and it is not reasonably commercially available, i.e. out of print, a library or archive may reproduce, distribute, display, or perform in facsimile or digital form a entire copy of the work. So this is pretty awesome. And this happened when, you know, Disney got all up in arms and they were extending copyright for 20 more years. And it was a compromise between libraries and big corporations. And the library said, hey, you're making copyright term even longer, right? Remember how I said it was back in 1920s, it was date of publication plus 95 years. Well, it used to be like 56, then it was 70, and then it was 95. And so they got this kind of buyback of the last 20 years. And some of you maybe have heard of the Internet Archive project, where they are putting a lot of books that are in the last 20 years of copyright online. So that is something that libraries are allowed to do. If the book was published within the last 20 years of its copyright term, and it is not reasonably commercially available. So that's just something to be aware of if you're into a big digitization project. And you could look up the Internet Archive and see what the good work that they're doing. So Section 108 reform has been going on since 2004. And like I mentioned, the Copyright Office released a discussion document in September of 2017 with a model statute. There's no indication this is going to happen anytime soon. Right now, the big news is the Music Modernization Act, which is going through Congress, and I'm really hoping President Trump won't sign it, because I really don't like the act. I think it just complicates sound recordings from from 1972. But we'll see what happens with that. And the other thing that's been going on is the Marrakesh Treaty. I don't know if how many of you guys are familiar with that, but we've been trying to implement the Marrakesh Treaty. So there are other things going on. Section 108 is on the back burner, so we're stuck with it as it is for now. And again, libraries aren't getting sued, so I think that that is not necessarily a bad thing. All right. We're going to switch gears a little bit. All right. So we know that it's really easy to own a copyright, and we know that a lot of people own copyrights, and that things on the internet, even if they don't have a copyright symbol, might be copyright protected. So how do you legally use other people's work in your own work or your librarianship? So this is the way that I think through these issues. I go through it in order, and I say, first, is it in the public domain? If so, go for it, right? Second, are there any Creative Commons licensing that apply, right? Creative Commons is a way of coming between making a license between myself and the general public. It's not me and one person. It's me saying, hey, here's how you can use my work. And if there's a Creative Commons license on it, great. I also look at copyright exceptions because, you know, Section 108 is a copyright exception. If it fits within Section 108, then great. You can do something with that. If the exceptions don't apply or I'm extending them a little far, I'll get into fair use and think through that, which is a more flexible exception. And then last, I might ask for and receive permission from the copyright owner. I put that last because often, A, they're hard to find, B, they might not respond at all, C, they might say no, and D, they might ask for money. And oftentimes I just don't have any money. Blatantly though, you can exercise fair use even if someone tells you no, but you're much more likely to get sued then, right? Then they know what you're doing. So this is kind of the way that I think through these issues. We've talked about the public domain. One more thing that falls into the public domain are works produced by the US government within the course of their employment. So the Copyright Act itself is in the public domain. You can find it online very easily. Here are some examples of Creative Commons licenses. Anyone can put a Creative Commons license on their work if they own the copyright. So if you put a CC0 license on your work, you're designating it as part of the public domain, which means that it's basically no more copyright, right? You're letting anybody use it. If you use a CC BY, you're saying, hey, you need to attribute the work to me. I want to know that you said this is where you got it from, right? It's kind of the same as an academic citation, so you have to put the name and where you got it from and the author and things like that. Like I mentioned earlier, the copyright warning notice that I used from University of Michigan Library had a CC BY license on it. So I was able to change it a little bit. I was able to put my library's information and cite it as, you know, this originally came from the University of Michigan with their CC BY license. If you have an ND, a no derivatives license, that would mean that I couldn't do what I did with the Michigan work, right? I'm not allowed to change it. I have to use it kind of as is. I can't create a derivative work from it. And if you put a non-commercial license on there, CC BY or CC/NC, that means that you can use it for educational purposes, but you're not allowed to commercialize it. I'm not going to go through every single one of these, but you can find a lot of great information on the Creative Commons webpage. So creativecommons.org. You can search for things that are in the Creative Commons licensing. Images are on there. It's a really great place that I find things for conference presentations or even exhibits in the library. And you can also, like I said, put a CC license on your work. All right, there is an exception for face-to-face teaching. I'm not really going to get into that too much, but if you're in a classroom face-to-face, then you're allowed to show any kind of image you need to show. Note that it doesn't talk about reproduction or copying. It talks about display. So I can show you, if let's say we're in a classroom right now, I could show you anything I need to make my point for education, or I can show you a full-length movie even, right? As long as I got it from a lawful source. The reason this might be applicable to you is some folks I have extended the idea of face-to-face classroom use to libraries. I know the New York Public Library considers all of their library space to be classroom space because people are learning things there. So you might need to show people things, images, and all sorts of other things within the library. And if you consider that a classroom space, then you could fit your display into this exception. Okay. So I think that, the only other point that I ever make about this is, and this is a point about the conflict between the Copyright Act and licensing, is that some people want to show Netflix in class. And when you sign up for Netflix, you click through a license or an agreement, and it says that you will only show it for quote unquote personal use. Well, that prevents you from showing just anything you want from Netflix. Now, there are a lot of things on Netflix that they say you can use for educational uses. I don't want to say there aren't, but you know, if you're trying to show like, you know, a sitcom or something that's not generally has no exception to that rule, you're really not supposed to use Netflix. And that is the point about how copyright interacts with contracts. So if I contract away my copyrights to you, a publisher, now my copyrights are gone because the copyright kind of prevails. The contract prevails. And so that is true with licenses that libraries enter into with different service providers, with ebooks, with journals, all that stuff, right? That can kind of prevail. And it's a really important reason that you need to be very careful when you're engaging in negotiations for licensing to reserve any rights that you have under the Copyright Act. Having that clause in there is really important, or if you want to like say interlibrary loan rights and fair use rights or something like that. But if you just say, you know, the library reserves any general exceptions provided under the Copyright Act, that's a really great clause to have in there because that preserves your rights under fair use and Section 108. Okay. Which brings me finally to fair use, which is a whole topic on in and of itself. So fair use is included in volume 17 of the United States Code, section 107. And in the preamble or the introduction, it reads, the fair use of a copyrighted work for purposes such as criticism, comment, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. So we're done, right? We're completely done. I wish we were done because that would be great. That would mean everything that I do at the university is fair use. Everything we do at libraries is for research, things like that. That's just the introduction, but it does tell us that what we do as librarians and educators is squarely within the purpose of fair use, right? So that's a good thing. It's not the end, though. The fair use statute goes on and says, in determining fair use, the factors to be considered shall include the purpose and character of the use, including whether such use is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used, and the effect of the use upon the potential market for or value of the copyrighted work. So this tells us we have to look at least at these four things. Now, judges were told this by Congress, right? Congress tells judges, this is what you have to look at. And judges also can look at other factors, and they do often. But they have to at least look at these. And I would tell you, I mentioned earlier that Section 108, there are like no cases. Well, if you look up Section 107, which is fair use, you're going to find thousands and thousands and thousands of cases. So that's a mixed bag. It's good and bad, right? Good because it helps us understand the contours of fair use a lot better. We can understand it a lot better. Like, I don't know what the premises of the library means, right, in Section 108 because no judges told me and there's really nothing in the statute. I know what nature of the copyrighted work means because a lot of courts have told me, right, in different cases. But the bad news is that the risk is higher, right? The risk of lawsuit is higher because more people are getting sued and there are more cases out there. So when entering into fair use land, I encourage folks to do a risk assessment and to think about it because fair use is interpreted by courts as an affirmative defense, which means that you can be sued even if something's a fair use and you have to assert that it's a fair use and answer that lawsuit, right? So it doesn't mean you're always going to get sued, right? And especially with libraries and the Digital Copyright Millennial Act, when you have a website, often you're getting like a takedown notice and it's really random and you can respond and say, this is a fair use, and they might go away, right? But I'm just saying you should always, when you're in fair use land, you should at least have risk somewhere in your thought process, and you should think about, is this a low risk activity or is this a high risk activity? And by risk, I mean, you know, risk of being sued, risk of, you know, damages against you, etc. Okay. So let's go through the factors here. The first factor is the purpose and character of the use. So I hope that you appreciate my copyright humor here as I abbreviated fair use FU. My good friend from UCLA does that, and I just think it's really funny. So hopefully I'm not offending anybody. But I put this on a kind of a spectrum. So the more commercial your use, the less likely it is a fair use. But the more educational or nonprofit your use, the more likely it's a fair use. Doesn't mean that just because it's commercial, it's not a fair use. It's just that it's, that factor might be a negative. The second factor is the nature of the work. If it's unpublished or highly creative, it's less likely to be fair use. So part of that reasoning is, my Aunt Marge wrote this diary and she never wanted it to see the light of day. She should have the determination of whether to publish it, not me. Or if it's highly creative, well, it was harder for them to make it, like Harry Potter. That's part of that determination. Versus if it's published and it's factual or historical, it's more likely to be fair use. The next factor is the amount used. So if you copy the entire book or you copy the heart of the work, then that is less likely to be fair use. Versus if you take a small amount. So one of the classic examples that I use with students is block quotes, right? People block quote from books all the time in their papers, their academic papers, and they understand that it's not plagiarism when they cite it, but that doesn't cover the copyright implications, right? On the book jacket, it says, no one may make any amount of this book used without express permission from the publisher. But none of these students called the publisher and said, can I block quote from this book, right? Because it's a fair use. They're using a small amount. They are using it for an educational purpose. And critically, they're using it for a substantially different market, right? No one's going to read my thesis about the strong female characters from Harry Potter instead of reading Harry Potter. At least I hope they're not going to, because I think my hypothetical thesis is really boring, right? It's not going to replace the marketplace for the original work. So that's one of the factors as well. So there are two ways to kind of think about fair use. One way is with quote unquote straight copying. If you are just saying like, oh, I have an e-reserve policy and this professor wants to make one chapter of this book copied for his or her class, do I need to like pay for that chapter? Then you're going to do a straight four-factor analysis. There's nothing different, no new purpose for that work. They're not doing anything exciting with it. They're just making a straight copy. And you have to ask, what's the purpose? How much did they take? Is it the heart of the work? And the heart of the work would mean like, the biggest part of this book, like let's say chapter 2 is the seminal chapter. Well, maybe then you probably do have to pay for it, right? That's something that professor would know best. Whenever I counsel professors about e-reserves, I tell them they're in the best place to make a fair use decision about their use more so than I am, because I don't know what that particular piece or that particular book says, right? There's no bright line rules about how much you can use of a work for it to be fair use. I know there's a big myth going around that it's 10% or one chapter, and I know where that comes from. It comes from the Circular 21 guidelines from the United States Copyright Office. But I'll tell you this, none of the language from the Circular 21 guidelines was actually in Section 17 of the United States Code at all. Actually, we've seen the entire section of the code. I read it to you earlier. So don't be fooled by that. And even some courts have said there's no bright line rules. This is a case-by-case basis. All right. So bear that in mind when you're doing those e-reserve thought processes. Another thing I will tell you is if you've been talking about fair use and you haven't been talking about transformative fair use, then you're a little bit behind the times, because in 1994, the Supreme Court in Campbell versus Acuff Rose Music came up with this transformative test. 1994 is quite some time ago, so this has been going on for a while. And in that test, the court said a transformative use is one that alters the original work with new expression, meaning, or message. Okay, so What does that mean? My colleague Kevin Smith says that courts generally look at two things. They look at, does the use transform the material by using it for a different purpose? And again, we're not talking about straight copying, because copying a chapter is not a new purpose, right? It's the same purpose as to read the chapter, but it's for some new purpose. And was the amount taken appropriate to the new purpose? Did you take an amount that was necessary for that new purpose? Let's look at an example. So let's look at the Campbell case. What was it about? It was about a parody of the lyrics to the song Pretty Woman. We all know that popular song, Pretty Woman Walking Down the Street, right? And in that case, the Supreme Court explained that a parody, not a satire, at least to them, is a fair use. I'm not going to make anybody explain anything because you can't, but I'm going to explain it here. All right, so parody is when you're making fun of the original work, and someone has to think of or conjure up in their head the original work in order to understand what you're making fun of. Satire is when you're just making fun of something different altogether, like making fun of society, making fun of something else. So the court said the heart of any parodist's claim to quote from existing material is to use some elements of a prior author's composition to create a new one that at least in part comments on that author's work. So that if you're parodying, you kind of need to take more of the work so that they understand that you're making fun of it. So this was that example, Roy Orbison's Pretty Woman. Two Live Crew made a really bawdy parody of it, and you can find it on YouTube and listen to it later if you want. It's called Pretty Woman, but it's the lyrics are Big Hairy Woman. Here are some of the lyrics. Big hairy woman, you need to shave that stuff. Big hairy woman, you know I bet it's tough. The Supreme Court wasn't really sure why, but they found it to be a parody. They were making fun of Pretty Woman, and they even took the lyrics of the first verse. So when you listen to the new one, you're going to hear them say Pretty Woman walking down the street. And they said, you know, that's transformative. There's a new purpose to this. So after that case came out, a new case came out. The Cat Not in the Hat, the O.J. Simpson murder trial. So someone put O.J. Simpson in the Cat in the Hat's hat and he was holding a bloody glove. So do you think that this is a parody, or is it fair use? So you can say yes, fair use, or no, not fair use. So yes would be like A, B would be like no, it's a satire. So we should be doing a little poll. Let's see what we think.
The poll is up. I'll give people just a few more seconds to vote. All right. Oh, this is kind of split. 52% said yes and 48% said no.
Okay, so the judge thought that it was not fair use because the judge said that they were not making fun of the Cat in the Hat. They were making fun of something entirely different, right? The Cat in the Hat is all about when parents go away, the kids are going to play with this cat. It has nothing to do with murder and like a bloody glove and all that. So they, even though it's interesting because their lawyer, the lawyer for the guy was like, oh, put a parody on the cover and it'll be more likely. The judge was not fooled. The judge said, no, even though you said it's a parody, it's not, it's satire. And the judge said, nope, you don't get to do that. You were being lazy and you need to pay to use the ideas of Cat in the Hat. Let's look at a different example, a more modern example. So the Second Circuit looked at this case of Carew versus Prince. Carew is a photographer, and he took this picture on the left of folks in Jamaica, Rastafarians. And Prince is not the late great singer Prince, but a misappropriation or appropriation artist who took the photograph without permission on the left and turned it into the thing on the right and sold it as art. Now, he didn't sell this particular painting picture to Jay-Z and Beyonce, but he has sold his work to Jay-Z and Beyonce for millions of dollars. So he takes other people's work and he appropriates it and he doesn't give them any credit and he makes millions of dollars. So of course, yes, he gets sued a lot. So what do you guys think? I'm going to ask you, is this a fair use, yes or no?
Did we have a poll for this one?
Yeah.
Okay. Sorry, let me go find it. here we go. All right. I'll give everyone just a couple more seconds. All right. So this one, the results say 28% yes and 72% said no.
Yeah, that's a really good thought. I mean, so if you look at the 4 factors from fair use, which the courts have to look at even with transformative use, the transformative use tends to gloss them, right? They'll say things like, it's commercial, but it's transformative, so it's okay. Or, you know, they took the whole thing, but they needed to because it was a parody, so it's transformative. Here, it's highly commercial, right? He's making money off of it. He took the whole picture. He did not much with it. You know, arguably there's a new purpose, like, right, the original purpose was to document people in Jamaica, and his new purpose or message is, I don't know, rock and roll or something. I'm not really sure what it is. But I'll tell you, I gave you this one because the court in this case was like, I don't know. We're not sure if this is fair use or not. They didn't say no. They said, we're going to remand it to the lower court to let them figure it out as a matter of fact. Some of his other pieces did a lot more, and they found that it was, as a matter of law, a fair use, transformative. This one they were a little stuck on, which, yeah, you guys were a little stuck on too, a little bit half and half. But in this court said, hey, we're over this whole parody satire distinction. They said, Prince's work could be transformative even without commenting on Carews' work or on culture, and even without his stated intention to do so. They said, we don't care if he comes to court and says, this is what I meant to do, and I was making comment on this guy's work. They said, we don't care. That's not what is meant. So what is the test? Well, the test is that one has to alter the original work with new expression, meaning, or message. We're back to the very beginning, right? We're no longer in this like parody versus satire. Now, I will tell you, in the world of parody, we are very clearly in the realm of fair use because that is the Supreme Court, right? So telling us, yeah. But in other worlds, we're extending transformativeness past this idea of like commenting on the original work, and we're saying, hey, as long as there's a new purpose, that's okay. So let's look at an example after that case that found a transformative use. So there's a man who is a really big fan of the Grateful Dead, and he wanted to write an anthology of the Grateful Dead, and he took a lot of posters from the Grateful Dead era, and he wanted to put them in his book. So he asked the artist of these posters, hey, can I use them in my book? And he said, of course, no. But he did it anyway, and for some reason his publisher was okay with that. They published the book, and then they got sued, and they defended the lawsuit. They argued it was a fair use, and the court agreed. The court said, hey, the purpose of those original posters was to advertise Grateful Dead concerts. The purpose in this book is to put it in a historical context. He even put these posters in a timeline of what was happening at the time, and he shrunk the posters down, right? They were nowhere near their original size. No one is going to put this man's book on their wall instead of the poster. He's not transplanting the marketplace. It is commercial, but it's transformative. And the court said, we're okay with that. And one of the morals of this story is, even if someone says no, you can still use the work and claim that it's fair use. Now, like I said, your risk of getting sued goes up because now they know what you're doing, which is exactly what happened in this case. Here's another example. So, and we're going to have a quiz at the end here, a yes or no. The HathiTrust Digital Library inputs entire digital copies of books and other materials into the library. For copyright protected works, the general public cannot see the entire book, but can search for how many times a specific term is used in that work. So if I'm looking for a book on anaphylactic shock, for instance, I can search anaphylactic shock, and if it's a copyright protected book, it will tell me anaphylactic shock comes up 95 times in this book or 0 times in this book, right? Is that a transformative use? Let's see, yes or no?
Okay, the poll is open. Give everyone just a few more seconds to vote. Everyone's being really quick today. Thank you. All right, closing it out and sharing. 71% said yes and 29% said no.
Okay, and I agree with you, and the court did too. The court said the purpose of the original materials was for communication or reading, right, ingesting the materials, and the purpose of the research, the numbers from the Hathi Trust, is for research, right? If I want to know all about anaphylactic shock and this book has it 0 times in it, that's not a very helpful book to my research, right? So yeah, they said this is very transformative. And also a similar thing happened with Google Books, right? Except look at the difference between Hathi Trust and Google. Hathi Trust is a nonprofit library, digital library. It's a consortium actually of research libraries. Google is a very, very for-profit international corporation. And yet Google was making entire copies of books. And when we search for books that are in copyright, we see what's called the snippet view. And in the snippet view, we see the word that we're looking for highlighted in a couple sentences. And the court said, hey, that's okay, because again, that's for research. Like, I need to know if I'm looking at a book that's about Albert Einstein when I search for Einstein, or a book that's about Einstein the cat, which is like a popular animated feature, right? So they said that's all right. And notice that in these scenarios, they're making the entire copy of the work, and they're making multiple copies, because what's happening with Hathi Trust is that they are getting these copies from different libraries of in copyright works. Then they're putting them into a database, and then they're also giving a copy to Google. They're all collaborating together. And the court said, totally okay, that is a fair use. So fair use is a really powerful tool for libraries. I think I'm getting towards the end, because I really do want to save a few minutes for questions. So if you have questions, you can start thinking about putting them in the question box. I don't think I've seen any more as we've been going. I've tried to keep an eye on them. All right, here's my last question for you. Is this transformative? So on the left, we have the Associated Press photographer took a picture of Barack Obama sitting next to George Clooney at the National Press Club. And I'm pretty jealous of either one, because I mean, I'd like to be sitting next to George Clooney or Barack Obama. I would be okay with either one of those. But he took that picture, Ferry did, this artist, and he turned it into the Hope poster, which some of you may have seen. And he sold it. He was selling it for money. And the question is that a transformative work? Is he transforming that with a new purpose, meaning, or message sufficiently such that even though it's commercial, it's an okay use? What do you guys think? Yes, it's a fair use, transformative, or no, it's not?
I opened the poll, so it's giving everyone just 1 or 2 more seconds. All right, 73% said yes and 27% said no.
Yeah, so I mean, there's a pretty good argument here, right? That he's changed it enough. He isn't using the whole picture. He's maybe arguably using the heart of the picture. I don't know what the heart of the picture would be. If you think Barack Obama is the focus, which he does kind of look like the focus there, but then you also have a new message, which is hope, right? The first purpose was just documenting what was going on, like a factual documentation, and the new message is like a political one. But interestingly, Mr. Ferry got sued and he ended up settling, so we'll never know what the court would have said. In the end, he promised the Associated Press that he would never use their photos again without permission, and he gave them all the profits he got from this particular poster, and he donated them to where the AP told him to put the money. So in a way, he did lose, but we'll never know what the court would have said about that one. But I guess one of the things I'd like to raise, though, is that, we use transformative fair use, at least I do a lot. I do it in my teaching. I do it in creating exhibits for libraries. I do it when I go and present at conferences. We do these things all the time. and you should feel empowered to do so, either using the 4-factor test if you're just making straight copies, or if you're embedding things into other things and kind of creating a new expression under transformative fair use as well. Oh, I also create library guides. I'm sure some of you do that as well. That's another place that I use fair use. And I have some practices here. I feel like we've done kind of a lot of practice, but I'll leave that and say, hey, let's see if we have enough questions to take up the time. And if we don't, we can come back to it. So does anyone have any questions that are burning at the moment? If you do, feel free to write them into the question box.
Sarah, we did get several questions come in, so I'm not sure if you're not seeing them, and if not, I can read some out loud.
Yeah, go ahead. I'm not seeing them. I only see the ones I've already answered. I don't know why. So yeah, go ahead and read them.
Can you go back to the picture with the Rastafarian man and Prince? Can you repeat what the ruling was on that?
Sure. Well, so on this particular photo itself, the court remanded it to the lower court to decide whether it was a fair use or not on the basis of facts. So the appellate court is only supposed to make rulings on the basis of law and not facts. So they couldn't figure out if, as a matter of law, it was a fair use. They did make some rulings on some of the other photographs at issue that it was a fair use. So you really have to kind of parse that case out a little bit. I picked this particular picture because this was one of the ones that they weren't really sure about. So I think it's more interesting. And you guys were a little bit unsure about it too, which is not uncommon.
Okay. Going back to section 110, the copyright exception for teaching, it says face-to-face teaching. How does that apply in the online teaching world?
That's a really good question. And yeah, this is one of those reasons why teaching face-to-face with you guys is a lot better, because I always get that question. And the answer is that there is a very poorly drafted online teaching act called the TEACH Act, T-E-A-C-H, and it's just really bad. It's another example of where Congress got their hands on the law and made it unruly with too many requirements. Like one of the requirements is people have to like not be able to get back into the course as soon as the course is over, and not be able to download anything from the PowerPoints and this and that and this and that. There are a lot of technology requirements and things. I know the Information Science School at University of Illinois, for instance, does not follow the TEACH Act, because even though they teach a lot online. So then the question is, where are you, right? Where are you when you want to use things and you're online? And the answer is you're in the realm of fair use again, right? And that's okay, right? If you get comfortable with it. Right now I'm in the realm of fair use. You know, look at these pictures that I'm using. Well, I don't own these pictures. Karu owns a picture on the left, and Prince debatably owns a picture on the right. Karu might own both the pictures, right? But I'm teaching using the pictures. I'm using them for a specific purpose. And my purpose, you know, we're talking about them, we're voting on them, I'm not using them just to show the image. I'm using them to teach you about it. So it's a fair use, right? And that's the realm that you get into online when you're teaching online. That also reminds me that I should recommend to you fair use checklists, right? So when you're deciding if something's a fair use, it's not a bad idea to kind of fill out a checklist and keep it in case one day someone asks you, like, why did you think that was a fair use, right? And technically you're supposed to do it for every single like thing that you're using. So if you're doing an exhibit and you have 3 objects in it, photos, copies or things, and they're not public domain or Creative Commons licensed or what have you, then you could fill out a fair use checklist for each one of those and then keep it in a file, and just if anyone ever asked, you'd have it. There are many different fair use checklists. I don't have a favorite one. One of them is by Kenneth Cruz. You can find it on the Columbia copyright page because he used to work at Columbia. Another one is by the American Library Association called the Fair Use Evaluator. And yet another one was by Nancy Sims at University of Minnesota. She has a really good fair use tool as well. All of these tools allow you to, print out a copy or keep a copy of your analysis. So it's always a good idea to kind of just keep it. But you don't have to use a checklist. You could just jot down, your rationale too. I mean, it depends on what works for you. Or you could do it in your head, right? But I mean, a lot of people like the idea of kind of having a record of it, and it's not a bad idea. And so I don't tend to do it myself too frequently because I'm pretty comfortable with fair use and applying it. But if I do it, if I were going to, let's say, like publish a book and I was going to include an image in it and I felt like I needed to assert fair use, I didn't have the permission to use it and I felt like I didn't need it or didn't want to get it, then I would probably fill out an assessment.
All right. We had a couple other questions. Does classroom use extend to training in a workplace environment? Whether that's a government agency or a special library or something like that. It's not a traditional school classroom, but
yeah, that's a really good question. I'm gonna pull that up. It does say in the actual statute, it says performance or display of a work by instructors or pupils in the course of face-to-face teaching activities of a nonprofit educational institution. So you would have to fit that, whatever that thing is, into the definition of a nonprofit educational institution. So if you cannot fit it into if it's for profit, for instance, then no. If it's not considered an educational institution, then no, right? So I think that's the issue. And I do think, like I said, people have extended that to like public libraries. They're nonprofit. They feel like they're educational, right? And I think, universities and things, most universities are nonprofit. Even private universities are nonprofit. There are some for-profit universities, so they're pretty rare. But it does have to fit within a nonprofit educational institution. So that's the barrier there.
Okay. We had a couple questions about going back to libraries creating a digital copy. Can a library card, or if the library posts something online, can it be protected by a password or a library card? Would that fit?
Yeah. And that's where I can't answer that question for you, right? Because I think it depends on how you view the law and how comfortable you are with risk, right? Because I think clearly, I don't think anybody can debate, and again, this is only for specific sections of Section 108, right? We're talking about preservation copies of unpublished or published materials, and the published materials are ones that are deteriorating, blah, 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 or obsolete. We've got to like remember where we are in the law, but I would say the answer is I can't tell you the answer because again, Section 108 is pretty ambiguous and we don't have any case law interpreting it, and so it becomes an issue of how risk averse you are or non-risk averse you are. If you are pretty confident that you have, for instance, sovereign immunity, like you can't get sued very easily because you're a state actor, or the university usually can't get sued for officers working in the course of their duties, et cetera, then you might feel a little more comfortable with taking a risk. If you are like a small library that's like more private looking, then you might feel less comfortable. So it really depends on how you kind of view the law and how you interpret it and how you're kind of willing to interpret it. But again, I don't think there's a clear answer there. And I think it's a matter of interpretation, and people interpret it differently. And I know libraries that interpret it really broadly and say, hey, we're just going to say that this is anywhere that anyone can like log in. I mean, obviously you have to be able to do that. We're not going to put it like on the open web, but if you have a library card and you can log in, we're going to say that that counts. And others will say, nope, this applies if you come into a library and you log into a library computer physically in the library. So it really depends on, how comfortable you are interpreting it broadly.
Okay. You had mentioned Hannah Sisline's webinar that she did a couple weeks ago specifically about copyright and standardized right statements for digital collections. And we did record that, and I just shared the link in the chat if anyone wants to go back and look at that.
Yeah, I mentioned it in particular because of the copy fraud issue of libraries that say, oh, we made a digital copy of this public domain work and now we're going to put a copyright owned by the library. It's like, oh, please don't do that, because if it's actually public domain, people are going to rely on, what the library says about it. And if the library says it's copyright protected by the library, that's actually inaccurate. And so, yeah, what she was talking about was one way that libraries are trying to standardize the way that they talk about copyright in the metadata and online visually for the user, so that they can get accurate information about how they can use that digital object. And I think it's really important to try to be intentional about how you explain, what the copyright status is of works, because just saying everything on our library website, including everything we've digitized, is copyright University of Illinois Library, that's just not true. I mean, we digitize a lot of stuff that is in the public domain, and we try to label it as public domain so that folks know how they can use it.
All right. We had a couple questions about blogs. One question was, is it okay to take a screenshot of a blog and repost it? Is that a violation of copyright? And then the other was, if somebody has a personal blog, is it fair use to quote from a speech that somebody gave? Any thoughts about
on their
those
blog?
questions?
Like, I mean, if their speech was like written on their blog, so I'm assuming that's what they're saying. I mean, the whole thing about quoting is quoting, right? Like it's usually a fair use, and usually you're being critical or commenting on it, and that's all what fair use is all about, right? And especially if you're taking a small amount, they might be arguing something else, like, oh, it's defamation or something, but it's like they said it, so I mean, but in terms of copyright, like if you're just taking a small amount and quoting, that's usually a clear fair use. In terms of taking a screenshot, I think then it depends, right? Sadly, a lot of the answers that lawyers give is it depends, and also I can't give you legal advice as a librarian, so I can only just say like what I think, and people have to make their own fair use determinations. But a screenshot, yeah, are you making a copy? Yes. Is it copyright protected? Yes. So then you have to decide, is it a fair use? And then it would depend a lot on the circumstances of what you're doing with it. Are you being critical of it? Are you commenting on it? What are you doing, right? Because one of the things we have is like a lot of book reviews. I just wrote a book review and I quoted from the book a ton, and I described what the book was all about. But am I allowed to do it? Yeah, I don't need permission of the author to do that, because I'm being critical of the book, and that's a fair use, right? So are you being critical of the blog? Like then, it's more likely it might be a fair use, like the parody example where you're kind of like, you have to take a lot of it to make your point. But again, that's a decision that whoever's making the use of that screenshot would have to make that argument.
Okay. Going back to interlibrary loan, we had a question about if it was okay to send a link to an article if it's available. And the person who asked the question didn't really elaborate, but I'm assuming, they found an article in an online database that, their patron needs. What about that?
I mean, if the online database is like available to anyone, like that just seems like then there's no problem, because anybody could have gotten to it. Because
Not
usually,
sure. I mean, maybe the
yeah, I
person can
don't know.
elaborate.
I don't know. Yeah, I don't really know, but I would say in general, in terms of online databases with like publishers, there are a lot of licensing things that apply there, right? And so you've got to understand, like, who am I allowed to give access to these, like, for instance, like for U of I and our licensing, like, who gets access to all of our databases? Like, we have so many materials in our journals and databases. Well, that's for our current students, and alumni don't count. Like, once you leave the U of I, like, you're cut off. You don't have access to all those things anymore because we're paying like by like full-time equivalency and like understanding like how many students do we have. We're not talking about like anybody who ever went to the U of I, right? That would just blow up our numbers. So it really depends on your licensing, a lot of that, I would think. But, and again, remember that licensing can trump your copyright, general copyright rules.
All right. Well, it's noon, and I know we had a few more questions, and I'm sorry we didn't get to all of them. But Sarah, is your last page your contact info?
Yeah, I'm going to go back to that. Yeah,
All right.
so feel free to email me if I didn't get to any of your questions and you still have questions, or even if I did get to your questions and you still have questions. You know, I'm really happy to talk to you, and I have a lot of library guides. This is just one of them, but feel free to look at them. Most of my guides are Creative Commons licensed, so feel free to copy them and use them. Just give attribution where due, and I'm always wanting people to use my work. It makes me happy when good copyright information is out there. So please let me know if I can help you in any way doing your daily job, because that's what I'm here for. So.
All right. Thanks, Sarah. Do you want to mention your podcast?
Oh, sure. I also have a podcast, and I talk about copyright for pretty much a general audience, but a lot of folks who are interested are academic librarians or librarians in general, public librarians. And it is called Copyright Chat. But the easiest way to find it is to search for my name on like iTunes, because the copyright is the copyright symbol and then hat. So it's really hard to find. But anyway, if you're interested in that and you can't find it, let me know. I can send you a link. But I'd be happy to have listeners.
All right. Well, great. Thank you so much, Sarah, for your time today and sharing your expertise. I think this was a really in-depth look at copyright, and I think it was really helpful. And thank you all for joining us today. Sarah did give us permission to record, which we are very grateful for. So once I process that, I'll post it on the Rails website, and I'll send you all the link. So I think with that, we'll go ahead and end the webinar. Enjoy the rest of your day. Thank you again, Sarah.
Thanks. Bye.
Bye.